Attorney Melissa Mortensen is the founder of Mortensen Law Firm, LLC. She's passionate about helping small business thrive through sound legal advice, fortification, and education. Melissa enjoys sharing her legal knowledge with new, potential, and long-term business owners. She received her JD at the Indiana University Bloomington School of Law in 2006 and was admitted to the Wisconsin Bar in October of that year. She serves as a board member of the Solo Small Firm and General Practice section of the State Bar of Wisconsin. Please join me in welcoming Melissa Mortensen.
Thank you. It's great to be here this morning, and especially in talking to a group of people who I love, which is small business owners. And the reason I love small business owners is because of the courage and to face the risks that we're going to talk about and keep going and really make something of your dreams and your plans. So as we said, today our subject is legal risk management for small businesses. And I'm hoping that the information that we have today will help you all in strengthening your businesses. So first, I have a little risk management of my own to do. This is the somewhat required disclaimer that this presentation is for general informational purposes, that it is not to be considered to be legal advice, which would be specific. Legal advice would be specific information on your personal or business information, which we can't do in this forum. And to remember that this presentation does not create an attorney-client relationship. So
please silence your cell phones. Not turn them off, just silence.
Okay. So now that we have gotten my risk management over with, we can move on to our presentation. The first question is, what is risk? The Black's Legal Dictionary defines it as the chance of injury, damage, or loss, a danger or hazard. So risk is basically something that could cause damage to our business in some way. This is through loss of income, loss of property, loss of goodwill, injury to ourselves or others, and these are all things that we need to be aware of and ready to work with. As you can see from my word cloud, there are more types of risks than we can discuss in the time we have today. This word cloud does not include every type of risk that your business can face either. I've chosen a couple of sources and areas of risk that I think are common in small businesses, so that we can concentrate on those. But before I introduce them, if you look in your packets, the first page in the paper-clipped portion, there is a short quiz. If you could go through and answer those questions. We'll be going through the answers in the course of the presentation. As I said, we're going to be going over the answers throughout this presentation, so you might keep that handy along with the page for taking notes. Next, we have our first quiz question is it possible to avoid all risks? The answer to this one is no. Some risks are going to be impossible or impractical to avoid. Other risks will be difficult to predict. In these cases, it's important to do what we can to identify risk and make plans to avoid or prepare for the risk when possible. One of the issues that we can also deal with in the risks that are difficult to predict, one risk that all of us face are, whatever the new big bad computer virus is. We can't say what the next big computer virus is going to be, but by taking a step back and saying what can we do to protect our computers, we can prepare and work to mitigate our risk in that situation. So risks are part of the nature of business. It's not something that we can escape, just like we can't escape risk in our lives. And part of achieving business success is developing the ability to see risk and the judgment to determine what should be done as part of it. And unfortunately, if we spend too much time and effort on trying to eliminate all risk, we'll be in the situation where nothing can move forward in our businesses, or we'll be, in some cases, even taking steps that where our risk management actually brings risk in when we take things too far. So the challenge is to strike a balance that allows us to move forward while still protecting ourselves from the greatest threats that we face. The first thing we can do for this challenge is visibility. Visibility is determining what the risks are and learning how they can affect you. Visibility can also create opportunity. Opportunity in looking for ways to run our businesses better. Sometimes the risk is that we are missing out on income potential or profitability. And so in those cases, looking at our risk can actually help us in building our businesses and increasing the value of our businesses overall. The sources of risk that we're going to cover today are contracts, employment matters, liability, meeting legal requirements, and business entity management. These I chose because they're issues that I found come up frequently when working with small businesses, and where we can really talk about in a few minutes each regarding what you can do about them and where the dangers come from. So we now have our next quiz question, which is question number 2. The internet is a great place to find contracts that will suit my business's needs. And the answer to that one is no, not usually. I won't say that it has never happened, but the problem with contracts that are found on the internet is you don't really know where they are from or what they were originally intended to do. And that's a situation where, especially if you are not an expert with those contracts, you're opening yourself up to the risk that comes from having a contract that doesn't suit your needs and that isn't tailored to your purpose. The contracts found on the internet also frequently leads into what I like to call Frankenstein's contract. And Frankenstein's contract is when people go on the internet and they find a bunch of contracts and they say, I like this phrase from this contract and that term from that contract, and they smush them all together, and the end results from a legal perspective can be rather interesting, but they can also be very damaging to your business. And this is because terms used in the contracts will not necessarily be consistent. Different attorneys and other contract drafters have different writing styles and different preferences as far as how they will define people. And so if you have the parties are being called the party in the first part and the party in the second part at the beginning, and then it's the client and the vendor in the second part, and they're being referred to by name in the third part, you can have enter a lot of confusion into your contracts. And then you also have issues where sometimes contract terms will refer to each other, and if you don't have the entire contract, you're looking at a contract that a person who's reading it to try to interpret it will be saying, well, where is this these sections are numbered, where is this section C that I'm supposed to find important information in? So that is a big area where contracts can bring risk into your business. Other areas where contracts bring risk in are when we make assumptions. Contracts are often long and complicated, and frequently people in the position of signing them prefer to just sign them without reading them. I understand that reading contracts is not always the funnest thing to do, but especially when you're dealing with a contract that is important to your business, taking the time to either read it yourself or hire an attorney to read it and explain it to you can save your business a lot of time and money. Next reason is inexperience. I would say nearly everybody is an expert in their own business. The problem is if you don't have the legal experience or the experience in working with contracts to understand what's going on or what is a common term in your industry. And next we have legal technicalities. What is the effects of a specific clause, and one clause affect another clause. One interesting thing I have seen in contracts is, and this is actually was a case of Frankenstein's contract, where the clauses ended up contradicting each other, so that the end result was there wasn't really a contract because there has been so much contradiction going on. And then there are also, we should also know that there are some clauses that are just illegal, and if the clause is litigated, it won't be upheld in court. And knowing about that ahead of time can help us in making decisions regarding signing the contract or how we follow through. Because you don't want to be in the situation where you were counting on a clause that is just completely unenforceable. And next, some other areas of risk, we have the legal language and misunderstanding. Yes, I know that legal language is often very formulistic. In law school, I actually had a sheet on how to translate legalese into normal English. So that.
Yeah. Say, sell that little puppy.
I purchased it from the school bookstore, so it's. I'll see if I can find. I'll see if they're still publishing copies.
Yeah.
Well, I'll let you know if they have that available on Amazon. So there is that issue, and then just the fact that sometimes in contracts and other legal documents, a term that is being used as a legal term of art won't necessarily mean exactly what it would mean when we are talking about it in normal conversation. Another issue is the laws change. We have a ton of regulatory and governing bodies in this country, and sometimes small shifts in the law can end up changing how a contract will be enforced. And then there are the hidden risks, and hidden risks come from all sorts of things. One area is that if we have a great and perfect contract, they still need to be reviewed on occasion. You can have one situation I heard about recently was there was a contract that had been in place for decades without being reviewed, and now there was suddenly an issue where that people needed to look at the contract terms because of a breach, and they had discovered that this contract didn't really suit modern reality. So you need to update contracts from time to time so that they can best suit your business's needs and best suit the relationship that you're trying to build between you and the people who you're contracting with. But this moves us on to the question number 3. Because contracts are what we call private law, they can contain whatever provisions the signers want. And from what I've said earlier, you might guess the answer is no. Contracts do have a great deal of latitude in what they can contain, but certain terms are invalid for reasons of public policy or law. And there are examples that are frequently come in when you're dealing with contracts where it is generally understood that one of the parties is at a significant disadvantage to another. So for instance, in consumer contracts, residential leases, employment contracts. And so in those cases, being careful with your contract terms and knowing what will happen if a term is held unenforceable, because there are several things that courts can and will do. In some cases, they'll do something called blue lining, which is basically the court will say this term is illegal, but if we swap out these words, it'll be fine. In other cases, they'll say nope, this term is unenforceable, and so it's out. So knowing how the courts in your jurisdiction are going to handle things, especially if it's an important clause or one that is frequently litigated. And now we're going to move on to the world of employment matters with a question on independent contractors. So this statement is: a worker can be classified as an independent contractor based on either the IRS common law guidelines or the test set forth in Wisconsin statutes section 102.078, and that is the workers' comp statute, if anybody is interested. And the answer to that is no. In Wisconsin, if a worker is going to be an independent contractor, they need to meet both the 9-part test that is found in the Wisconsin statutes, and they need to meet the IRS's common law guidelines. The 9-part test is, and I actually like it in one respect because it is a very clear do this, do this, do this. The IRS guidelines, there's a little bit more of squish room in them as they are common law guidelines and various factors are being weighed. But those are things where if you're going to have independent contractors in your business, you do need to make sure that they are actually independent contractors as opposed to employees that you are calling independent contractors. The government is on to the fact that a way to avoid some of the headaches of employees is to hire independent contractors, and so they will check from time to time to make certain that you are actually meeting the guidelines. And there are penalties involved if you have independent contractors who are actually employees. In an independent contract, which isn't to say you should not have independent contractors, they are a great way to grow a business, especially when you're starting out or as smaller businesses where you don't necessarily have the work to hire somebody full-time or even on a regular, consistent basis. You just need to make certain that the guidelines are being met and that both you and the independent contractor are on the same page regarding that.
Should you ask questions as you're going along or saving for the end?
I was planning on saving some time for questions at the end, though if you have a question.
I just wondered about independent contractors. What if they're in other states or countries?
That we'd have to look at the test and see how and see what was going on with them, and if there were any issues of international law or state or interstate law that would apply. So.
What would be an example or two of the test?
For the Wisconsin test, they look at things like, are these people filing their taxes as separate businesses, or do they have a federal EIN number? In the IRS test, they include questions of, are these people acting like they're their own business? Will these people succeed or fail based on their own work as opposed to on your business's work? How much control do you have over their work? And like I said, both of these tests are longer, and the IRS test does include a little bit of weighing the circumstances. Yes?
You still have the 20 question for the safe harbor laws that really weighs as far as if a person's independent or not independent?
I am not certain on that.
Because that was something that was moved way back during, I think it was Clinton's days or whatever. It was 86, that was, safe harbor was taken away from independent contractors.
Okay. I know right now I've seen some reports that this is an area that government regulators are looking into right now, but I couldn't speak as to that point. But now that we've discussed the scariness of making sure that your independent contractor is actually independent, we're going to move on to people who you both agree are employees. And some of the areas of risk that incur when you have employees are work eligibility concerns. This is, are they a legal resident or citizen of the United States, and are they eligible to do the work that you are hiring them for? When you're hiring somebody, there are requirements as far as filing I-9s and establishing that somebody is eligible. But there are also issues where, in some cases, making sure that somebody has the correct permits and licensing to perform the work that you're hiring them for. Or if you're hiring minors, making sure that they have their work permit. Other issues are making sure that you are not being illegally discriminatory in hiring, and there are more ways that discrimination comes in than we typically think of. In Wisconsin, for instance, there are laws about not discriminating people for criminal records. And we can't go into exactly how those work because it's in a situation where sometimes you can, most of the time you can't. So those are things to be aware of and be very careful of when you are hiring somebody, especially when you're hiring your first employee, to go through and really make sure that you have a system in place where you are meeting all these requirements. The next issue that brings in risk is payroll setup and not having it set up correctly. Typically, I would say the easiest way to make sure that your payroll is set up correctly is to hire a payroll company. A good payroll company knows what they're doing, and will stay on top of these things. So I would say so that's a situation where you talk to a few and find one that really seems to know what they're doing. And next is training. Training is one of those fun things that can both cause risk and help you mitigate risk. But you need to make sure that employees are properly trained, particularly if they're using equipment or if they are interacting with your customers. You want to make sure that they know how to deal with a customer who is upset, or how to answer the phone so that they are creating the right atmosphere for your business. And you also want them to know, things as far as there's risk, their own risk management. How do they handle email? How do they handle confidential documents, etc. And then there's the question of liability for employees' actions, which brings us to question number 5. Employers are liable for actions taken by employees in the scope of their employment. The answer is yes. The doctrine of respondeat superior, no, that is not a typo, is employers are vicariously liable for actions taken by employees in the scope of employment. And this can actually bring in issues of if you are reasonably aware that a event could occur, or it can also include things like car accidents taken while using the company vehicles or while performing errands for the employer. So these are things to be aware of, that even though normally speaking in the United States, one person does not have liability for the acts of another, in the employment context, you very well can be liable. And now we're going to, since we're sort of on liability, we're going to move to the liability section with question number 6. If a customer signs a contract that includes a liability waiver, my business will be protected if that client is injured due to use of the business's product or service. We've, I think, all seen the liability waivers where it's, I understand that I'm doing something dangerous and I absolutely will not sue you. These things come up a lot with swimming pools, ski lifts, sometimes amusement parks, basically anything where there is a risk of injury. So the answer to this is, it depends. In Wisconsin, though, the answer is most likely no, it won't. The Wisconsin courts don't like liability waivers. When you go through the case law with them, it's very difficult to find one where they have been upheld, and it has been a long, long time since that has happened. Now, what the courts have done in the past couple years is they have hypothesized as to what a liability waiver that would be enforceable might look like, and what it would include. One issue would be that it is clearly labeled and that it is on its own sheet of paper. Another degree of enforceability is that a person has the ability to negotiate whether or not they will sign the liability waiver. And the negotiation is more than just, I will sign it and be able to engage in this activity, or I won't sign it and not be. There has to be some level of negotiation as to how they can not sign the waiver and still engage in the activity. So, yes, we have not had we have not had a case where the liability waiver that meets these guidelines has been litigated, but it's kind of up in the air as to whether or not a liability waiver that looks like that will actually be upheld.
Best to assume no.
I would say right now it
Or
would.
you're getting them to sign it just so that maybe they believe that they're there's something there.
Well, it actually brings up the point that part of the reason why it's difficult to get liability waivers enforced is usually by the time that they're getting up into the higher level courts, something very bad has happened. And that, so you typically have a very sympathetic plaintiff. But so with that, we're going to transition into more of what is liability. And liability is the general term for anything that your business could be held accountable for. And it can arise from things like accidents, which is a huge one, the actions of your employees, as we discussed before, human error, which can actually be little things like, we sent the confidential email to Bob Smith instead of Bob Jones. These things happen, and they can open people up to liability. And also negligence. And negligence is basically actions that are taken without the level of care that is normally considered reasonable. In torts law and law school, negligence is a huge section of what ends up causing people to have legal liability for things. And so these are cases where really developing systems and using some of the risk management steps that I'm going to talk about later can help you in protecting your business. But as we're moving on, especially since we started late, we have question number 7, where we are talking about the sources of law. And there are many sources of law that may have jurisdiction over my business. And I'm going to cut close because that answer was wrong. The answer is yes. There are lots of sources of law. We have federal law, state law, local law, regulatory boards, court rulings, and these aren't all of them. So one thing to remember is in many industries there are specific laws and regulations that you're governed by. My industry as a lawyer is one of them. There are tons of things that, as a business owner, I would love to be able to do, but I just can't because of the regulations that govern my industry. Even though I would say these are things that are perfectly fine for other businesses to do, and do not present any ethical concerns for other businesses, I can't because of my position as a lawyer.
Can you give an example?
I have a lot of restrictions on what I can do for advertising.
Yeah, it was
So-
only maybe 20 years ago that lawyers could even advertise.
Yeah, the legal profession doesn't really like advertising, and there are quite a few restrictions on what I can do in regards to advertising. So, and again, these are things that I would say for a business that is not in the legal industry, they would be perfectly fine and great ways to advertise. And so,
Another would probably be you having ownership in a client.
yes, I have to be careful about having ownership in clients, or what I take as payment. Let's see, trying to think of them off the top of my head. Making a non-lawyer isn't supposed to have a ownership interest in a law firm, so making sure that so I have to be careful about who I accept as a business partner, things like that. But then also to move on with legal requirements is don't overlook local law considerations. This is one where so many people, you're thinking about the federal law, you're thinking about the state law, and people just kind of don't think about what's going on in their communities. And sometimes what's going on in their communities can be the most significant law that they're dealing with. So some of the areas of local law that can affect businesses are zoning requirements. Can you actually have your business at the perfect location that you found? One story I heard was of a studio in a different state that found the perfect location. It met everything they wanted, except for there was one problem of they needed a slight zoning variance. Their realtor assured them this was not a problem. These happen all the time. and so they signed the lease. It was a problem. They found out that the neighbors did not want the zoning variance, and they ended up having to go through quite a bit of extra headaches before they could open up their business. So, so there's things like making sure that the zoning is correct, or that you can get out of the lease if it isn't. And also the question of occupancy permits. These are permits that basically allow businesses to operate at a specific location. In the Milwaukee area, each municipality has different rules. The city of Milwaukee does require that you have an occupancy permit before you begin business. There are other municipalities that don't require them at all. There are other ones that require sometimes but not always, and it's very dependent on which municipality within the Milwaukee area that you are going to be working in. And one issue with occupancy permits in Milwaukee is don't make assumptions. There's a fun story from a few years ago about the mayor of Milwaukee was in the middle of a campaign, as politicians frequently are, and his campaign office failed to get an occupancy permit because they made some assumptions about the eligibility, and they said it was an honest mistake, and that was how it was reported on, but they ended up having to pay a fine. So if you think about it, if the mayor of Milwaukee can make a mistake on this can be some pretty tricky stuff. And next is local permits and licensing. There are certain businesses that will require additional permits from your municipality. These are things like if you're going to open a bar or tavern, animal care, daycares, restaurants, a huge long list, and it will vary from municipality to municipality. So these are things that when you're deciding where to operate, especially in a community like our Milwaukee area, where you have lots of choices for your municipalities, is when you're picking your location, take a moment to look at what are the requirements, and are these requirements going to be, can I make them work with my business? And because skipping that step can end up causing you a lot of pain in the future. Now we're going to move on with the liability for debts, which moves us into our business entity management. Now, business entity management is an issue that is slightly different from the others, but in that business entity management actually encompasses bits and pieces of a lot of the other risk management sources of risk that we have discussed today. The reason I have brought business entity together is because it is an area that is frequently misunderstood, and one that I'd say nearly every business can benefit from understanding. So our question is, a business owner's personal liability for the business's debts varies with the type of business entity used for the business. Sorry, that's almost a tongue twister. And the answer is yes. Different business entities have different rules and rights regarding and protections that go along with them. For instance, a business that is run as a sole proprietor or a general partnership, the business owners will be personally liable for all debts and liabilities of the business. In a business that is run as a corporation or a limited liability company, which is frequently abbreviated as LLC, the business owners will usually be protected, though not always. Now, one of the big things to do with that is understand, what do we mean by a separate entity? A separate entity is a business that has a separate legal identity from the business owners. This is something where basically corporations and limited liability companies are the two biggest examples of this and the two most commonly used. But basically, if you've ever heard of the term corporate personhood or fictitious person, this is basically the idea that for the purpose of law and liability, that we're going to say that your business is its own person. We say that it's George right next to us, not you. And because of this, there is something called the corporate veil, which protects you from the debts and liabilities of your business. This is a huge protection because what it means is that you are able to protect yourself. It can there are other benefits to having a separate entity, though the major reason that most people will get one is for the separate entity protection and the limited liability protection. And this is basically where you are not going to be necessarily liable for the debts of your business. Liability will typically be limited to what the business owners have invested in the business. I'm going to take one brief side note and say I'm going to be using the term business owners and business in this presentation because corporations and LLCs do have different words for their business owners. They're shareholders in corporations, members in LLCs, but since we're talking about them as one, as separate entities, we're just going to refer to everybody as a business owner. The importance of having the protections for business owners are that if you have, let's say, you have contributed $10,000 to a business that has $1 million worth of capitalization. So there were a lot of people all donating or all contributing and investing $10,000 into this business. And they end up with $2 million worth of liability. Because of the limited liability protection, in most cases, you won't be liable for the additional $1 million that's out there. Before limited liability protections came in, first with corporations and then with LLCs, a business owner who had invested a very small portion of the overall capital could be held liable for the entire debts of the business. So that is why we have these protections. And that does lead us to question number 9, which is that the forming of a corporation or LLC provides business owners with automatic and complete limited liability protection. From what I said on the previous slide, you might be able to guess. Sorry, the answer is no. Forming the appropriate separate entity is an important first step. Don't get me wrong, it is a very important thing to do, and I usually recommend that to small business owners. But maintaining limited liability protection requires more than filing the paperwork. You need to take steps to show that you really are treating this business as a separate entity. As I mentioned before, there is something called something called the corporate veil, and what will happen sometimes is the corporate veil will be pierced in an action that lawyers like to call piercing the corporate veil. This is fortunately a not terribly common occurrence, but one of the most common reasons that it will occur is if you are not treating the business as a separate person, if instead you're treating it as an alter ego to yourself. The case that we read in law school involved somebody who actually had 5 or 6 corporations that he would use to pay his personal expenses with. Then he would have the corporation file for bankruptcy, and then he would move on to his next corporation, and was using that to defraud people. So in that case, it was determined that it was inappropriate to give him corporate veil, or to give him the limited liability protection. However, in cases where you are acting in a much more innocent matter, you can still lose limited liability protection if you are not treating the business as its own separate entity. And I would say one of the most important things you can do for this is get your business its own bank account. If you don't have your own bank account for the business, please do that immediately. And also, if possible, get your business its own credit card account. And use these to keep your business expenses and your personal expenses separate. You don't, because the more your personal life is intermingled with your business, the more you are opening yourself up to the risk that it will be concluded that you are not actually operating as a separate business. And also, another thing to do is to make certain that as you are engaging in business with others, that you are letting them know that you are acting on behalf of a business entity. This means that when you're working with contracts, you make certain that the contract heading says that this contract is on behalf of Widgets International, a limited liability company or a corporation. And when you sign the contract, you're not just signing your name. Instead, you're signing it for the Widgets International by Melissa Mortensen, owner. And that is something that can help put people on notice, and make people aware and give you that little bit of extra protection. Because even though piercing the corporate veil is usually not a favored remedy, it is one that is out there and one that is fairly simple. In many cases, it's fairly simple to protect yourself from. One other area I will say that causes problems with receiving protections is if your business is inadequately capitalized, especially from the beginning. If it loses money over time, you're not in as much trouble. But if you have a business that never had adequate capitalization, you could be opening yourself up to risk. As well as if you are when you are getting your loans, because frequently to start a business, you need money from somebody, usually the bank. If you sign a loan document from the bank and give them a personal guarantee, you've co-signed for your business and you are liable. This is why business owners will frequently talk about having their house on the line. It's not because there's a failure in the limited liability protection. It's more because banks and other lenders are aware of limited liability protection, and this is their own bit of risk management to make certain that they are safe. So another issue with business entity management is to make certain that you know what documentation your business entity requires. The different types of business entities do have different documentation requirements. LLCs typically have fewer paperwork requirements than corporations, but that is not to say that there aren't any requirements for LLCs. So, and keeping these things up to date can act both to maintain your corporate formalities, but it can also be a good time to do your own risk management. See, are things working? Do we need to make some adjustments to the bylaws or to the operating agreement? And things like that. And also just every so often make certain that you are up to date on the statutory requirements. So now that we've discussed some of the things that bring risk into our businesses, and I hope I haven't discouraged you. I am sorry about that.
Yeah, we don't want to get out of bed now because of all the things that are.
Unfortunately, not getting out of bed in the morning brings its own risk. There is risk everywhere. But now that we've discussed these, I'm hoping to end on a happier note and talking about what we can do about all this risk.
Yay.
Because a lot of these things, there is stuff we can do to protect our businesses from these risks. And that's why I decided to end with that so we can end on a much happier note. So that leads to the question of what is risk management? I would say the first thing that risk management is it's proactive behavior. It's looking at all of this, the unpleasantness that we've just discussed and saying, what can I do about it? What is there that I can do that will limit the risk, that will mitigate the risk, that will prepare for it, or that in some cases will just completely avoid it? Identifying the risks before they occur. This is looking around saying, what are the common risks that people in my business or my industry face? From my own common sense, do I think is something that is likely to occur? And knowing what those are. Knowledge is power. Working to reduce the risks where possible. Unfortunately, there are limits to what we can do to reduce risks, but other times we can reduce risk with in a relatively painless manner. Next, we have taking steps to mitigate risk. So this is basically, if the risk does occur, what can we do so that it won't be as bad? And then again, the planning for what happens if the risk occurs and there's without there being much we can do about it. For this, I have my risk management overview. There is a copy of this slide in your materials. The steps that I like to use are, first you determine what the risks are, then you plan for them, then you prepare, set up systems and review, and start over. So you can see in this next bit that seeing the risk is the first step, and that is why we spent most of the beginning of this presentation talking about all of the things that could possibly go wrong. Unfortunately, there are more than we have on this slide. But being able to see them is the first step to being able to deal with them. So the first step we have is to determine the risks. This is where you step back and you look at what risks can I see? What risks really jump out at me? What are the risks that are keeping me up at night or that are niggling in the back of my brain and making me wonder what is going on? And next you just sort of look around and brainstorm. What other risks are there? What do I think could feasibly be present in my business that could cause liability, or a danger or hazard? Next is you talk to your business advisors. These are people like attorneys, risk managers, bankers, insurance brokers, your business coaches, anybody who has expertise who can be on your team and help you use the benefit of their knowledge to say what could possibly open us up to risk, and that they know about, and that you can then use to know what it is that you are facing. And I'll say that with talking to your business advisors, they are frequently able to see things that you can't, or that are just right in front of you, but you've become so accustomed to it that it's just sort of in your brain. Your brain has identified it as this is something that's just there, while a fresh set of eyes can look at it and see possibilities that you've basically trained yourself away from seeing. Next is planning for the risk, and this is deciding what to do, basically deciding what actions should be taken, and considering the cost and resource requirements of your plan. For instance, there is the risk that a meteor will come down to Earth and wipe out a location. Creating a meteor shield to prevent that is a rather outsized response to that risk.
The probability is 1 in a million, by the way.
I'm sorry?
The probability is 1 in a million.
Okay.
By the way.
I will have to add that to this.
Same as a airline crash, a commercial airline crash.
We have a 1 in a million chance that a meteor will hit my location and destroy it. Now, I could, as a risk management plan, look into creating a meteor shield, or I could, at a much lower cost to myself, contact my insurance broker about getting some general liability insurance for what happens if there is a loss at my location. So there's the weighing of what is an appropriate step for the depth of for the risk. And then you should always, in planning, refine the plan to reduce the impact on your business. This is something where one thing I've dealt with is with computer passwords. There are some entities that basically will say we need to have computer security, which is a very good and important thing to have. But they will go so overboard on password security that they've created a situation where nobody can remember their passwords. So, guess what happens? Passwords end up written on Post-it notes next to the computer's monitor. That happens more than you would think. Hopefully with some of the new password software, it's less likely. But that is something where you have basically taken a very good risk management step and elevated it to the point where it is actually increasing the risk to your business, because they weren't taking into account the issues of human memory and what was reasonably practical for employees to do. And so keeping those things in mind as you make your plans, what is reasonably practical, what is necessary, and what can be done that will allow our business to protect itself while not incurring more risk. And next we have the preparations, and this is putting your plan into action. Making sure that the team members who need the plan have it, and reviewing implementation to make sure that the preparations are happening. The best plan in the world isn't terribly useful if if it is not being put into action. So for instance, if my plan to deal with the meteor strike is to get insurance, but I never call my insurance broker to get the insurance, I have failed in my risk management by not taking the steps necessary to prepare. And following the preparation, we can set up systems. And systems are basically where we take our preparations, take our plans, and say, what can we do to make this an easy to follow checklist, or what can we do to build into our procedures so that our chances of risk are being lowered. One thing is, again, making sure that you're following through on your plans and preparations. So in our insurance case, this might be something like putting a bank alert on your business bank account to say, okay, remember you need to pay your insurance, or setting up an auto pay for your insurance so that the policy isn't lapsing, and also making sure that the plans and preparations are being communicated to the appropriate people. In this case, I have a story from about the mid-90s with a young manager from an East Coast Toyota port facility. And this is one from somebody who I know personally, but he told me one morning he got into work about 7 a.m. on the East Coast, and to find there was a production error that meant that basically their production was shut down. And it was a huge problem for their facility. But because at this point Toyota was involved in really focusing on setting up systems, making sure that employees knew what they were supposed to do, and creating a culture where they were empowered to do it, he was able to go to his book of systems and look up what he was supposed to do in this circumstance, which happened to be calling up the executive vice president who lived in California. So because of that, he said he was still kind of scared about waking the executive vice president up at home in the middle of the night. But instead of being a young manager who was wondering, what am I supposed to do? And it's 7 o'clock on the East Coast, so it's 3 a.m. in the West Coast. We'll wait 4 hours and call up the person who has the information we need. He now had the ability in himself to make that call, to speak to a very groggy executive vice president who was able to let him know what needed to be done. And within a couple of hours, the problem was fixed, as opposed to waiting a couple of hours to put the fix into place. So this is something where the systems really can end up saving you time, money, headaches, and helping your business move forward. And our final step is review. This is where we make certain that the preparations are appropriate and that ongoing they're appropriate. What may be appropriate at one point can be inappropriate at another. This is particularly true when you're setting up risk management for computer systems as technology keeps changing. And also consider what you can do to improve the preparations. Talk to the people who are involved in the implementation, who deal with these things on a daily basis, and let them tell you how the system could be improved, and what can be done to really make it better for your business and better for everybody who has to work with it. So I'm going to end now, and I hope that we are ending on a happier note, because risk can't be completely avoided in life or in business, but we can use steps to manage it by understanding what the risk is, and then looking around to seeing what can be done to fix it and to move forward and use that information to build safer businesses. So I would like to thank you all for coming here today, and I'm going to be open for questions.
Go ahead, John.
I would like to, I'm a photographer, and as I hire photographers to do weddings or to do events, or videographers to do events, I would assume that because I have to tell them when they have to be there, they automatically become an employee, but in reality, they are not an employee.
One caveat is, because of my own industry requirements, I'm not going to can't give very specific advice. That one I would say is you would need to look at the tests involved from the IRS and the Wisconsin statutes to make that determination.
And the other thing is, I was told by somebody that if I ever sign anything that has my business attached to it, whether it be an order or whether it be a requesting, purchasing something, I always sign it, my name, president. Okay, so therefore I'm not putting a personal liability onto it, but I'm attaching that signature to the business liability.
So if it's a contract for your business, yes, you sign it in your role as the president of your business.
So if, you mentioned the example of like with a bank or in a contract, there is a possibility of piercing the corporate veil. So what do you, like, if you're the bank and you're saying, you need to do a personal guarantee, what can I as the LLC owner counter with?
That one, frequently, the bank is just going to require that you have the personal guarantee, especially if it's a large sum of money, and if it's a newer business. As your business ages and builds up its own credit history, you'll have a little bit more negotiating power in that, especially if your business does have substantial assets. Though at first, it will be very difficult to convince the bank, and possibly impossible to convince a bank or other lender to forego the personal guarantee.
Could you like say that the personal guarantee is valid for the next 3 years, and then is that something people do? I'm just curious because I just figured out, like I've done
It would
personal
depend. It would
guarantee.
depend on what the bank's feelings on the situation are. This is something where there could be a little bit of leeway, and if you could convince a bank to go with that, you might. But like I said, banks are another heavily regulated industry, and they have to protect their own risk managements and their business. So I couldn't say for certain that they would agree to that.
I wanted to re-ask John's question in a different way. Because my business and my name are very similar, is there an advantage of putting my title after my name when signing documents on behalf of my business?
Definitely. Whenever you're signing documents on behalf of the business, putting your title in is always a good step to take. So whether your title, and if you haven't assigned yourself a title, take a minute to do that. It can be shareholder, manager, president, but making sure that you have assigned yourself a title, and when you're signing on behalf of the business, you say it's, for instance, for me, it would be the contract party is Mortensen Law Firm LLC, by Melissa Mortensen, owner, and then under that, my owner, Mortensen Law Firm LLC.
Thank you.
In the state of Wisconsin, do businesses need to put LLC or incorporated after their business name?
That's something that will depend. So it frequently not, but sometimes yes.
What about a 501c3?
The charitable organizations will have different rules from businesses, and you need to look up what is required for them. And also, whenever you are in a contract, you definitely need to inform whoever it is in the writing that yes, we are this type of corporation, this type of charitable institution, etc. Right.
So Melissa, one of the big takeaways is when we're looking at risk, we need to look locally, federally, and within our industry specifically.
Yes.
Okay. All right, thank you.
And also look at what is going on specifically in your business.
And professional bodies and regulatory bodies.
I was trying to simplify it.
Right.
Basically.
Right. Well, okay, my question for you, I remember doing all of this the hard way, just trying to learn everything. And some of it's in sessions like this, some of it's
a session like this with Dan Mazer, for example, about human resources, and the checklist was pretty unbelievable. To hire one person with photocopies of photo ID and an I-9 and a electronic usage agreement, you know, and that they can't, I don't even want, I don't care if it's your buddy from high school, no jokes going back and forth because I don't want to be liable. That's just one area, that's just employment, and then you've got everything else in zoning and occupancy permits. You as an attorney, where do you start? I mean, if I just came to you and said, I'm gonna open a new business, can you take care of all this stuff?
I can take care of most of it.
Yeah, but it would cost me like 2 months of your time, I would think.
That would depend. I mean, I understand that a lot of small businesses do open on a shoestring. So now for me, what I do is I don't accept every potential client who comes in because I think that it's important to build a relationship of respect and trust. So I think in order to best serve my clients, I only accept those where we can build the respect and trust and not have personality conflicts. So there is that, but also what we can do is prioritize and sequentialize. Look at, okay, this is what we absolutely need to do first.
Take care of the most important things first.
And then you know, as things go forward, put together a plan for, you know, over the first year we're going to get these steps taken, and then we'll stop and look and see what still needs to be done.
Right, okay, well, the reason I ask that is because just learning something when you're going into it, you're the entrepreneur, and you're starting it, the learning curve is steep.
Yes.
Well, so how much, and I understand not just borrowing this and that phrase from different legalese stuff you see and putting your own thing together for contracts or disclaimers or what have you, but at the same time, I mean, zoning, occupancy, regulatory, all of this stuff, you prioritize. I guess that's the answer. You just prioritize because, and that I would think that if you're an advocate for me, you're going to try to hook me up with other advocates, so that I can learn from their experience instead of doing it the hard way.
Yes.
Or the expensive way.
Yeah, and like I said, for most, even though frequently when you're starting a business, it feels like everything is happening at once. Really, when you take a step back, it is possible to prioritize and sequentialize so that it isn't exactly. For instance, a lot of times one of the first things you'll want to do is get your business entity choice made and established. Yeah, the checking account you can do all by yourself.
Yeah.
And then you'll look at things like finding your location and what you need to do to move forward. I'm getting the signal that we are done.
Okay.
So,
Well, just
I
one
do
more
have,
thing to address your business name. You can do a DBA at the courthouse, clerk of courts for 10 or 25 a year, so that if you have a short name or something, you're doing business as.
Okay.
That's the way they use a short version of it.
okay.
Can an
I do-
LLC do a DBA?
Yes.
Yes.
I do have one more thing before I end. As a special bonus for those of you who have attended today, my firm does a lot of work on flat fee bases, and I have one product I've put together called a business planning session, and the information on that is in your materials. Anybody who has attended here today who contacts me about scheduling one within the next week, or actually 2 weeks, we'll say, can get a 45, 60, or 90-minute session at a $100 reduction of the normal price. So,
Very good.
thank you all. It was fun to be here.
Thank you.